Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this Honorable Court.
Good morning, everyone. I understand we have some guests here today. Welcome. We're glad to have you. And you'll hear a couple of arguments, and I believe we'll have a Q&A session with you after the arguments are over. Are there any announcements before we begin? Seeing none. Would you call the first case, please?
Metropolitan Government of Nashville and Davidson County versus Paramjeet Singh.
Okay, you may come on up. Begin when ready. Do you want to reserve any time for rebuttal?
I'd like to reserve at least 5 minutes.
Well, 5 minutes is all we let you reserve, so five it is.
I represent Paramjeet Singh, the defendant and the appellant in this case. He is a commercial driver. He was cited for careless driving by a Metropolitan City police officer. After the officer arrived on the scene and found that his truck had turned over in the roadway. This happened on Interstate 440 and 40. But the city police are the ones that arrived to issue the citation. And they charged him with a city offense, which I refer to city, meaning the Metropolitan Government, or
Yes.
the Traffic Violations Bureau. They cited him using their city code, Metropolitan Code of Law, for careless driving. And that's a purely civil offense in this court, in this law, punishable only by a fine of $50.
Has he paid the fine?
The fine has not been paid as far as I know. He did file an appeal bond which would cover the fine, I guess, if he's not successful. The defendant filed a motion for a temporary injunction to prevent the circuit court. There was a trial in the city court. It was appealed to circuit court. Motion was filed in the circuit court for an injunction to prohibit the city from forwarding the results of a conviction, if there was one, to the Tennessee Department of Safety. That motion was heard at the conclusion of the trial, and the judge ruled in his order, directly addressing the motion. The court found that under the key statute is 55-50-409. That's the reporting statute. It's the defendant's position, the appellant's position, that this statute does not confer the authority or the jurisdiction to a city court on a purely civil judgment to forward the results of a conviction.
Counsel, does that, let's say you assume for purpose of argument you're correct about that. Does that matter, though, here anymore? I mean, this case was moved to the circuit court. It was heard in the circuit court. A determination was made in the circuit court. So let's assume you're right about the General Sessions Court. Is that really of any consequence anymore in this case in terms of reporting this determination of violation here?
Well, it's our position that it is a serious matter, because that 55-5409 uses the phrases and the coins associated with the criminal procedure.
You're referring to the word conviction.
Conviction, the court of original jurisdiction, and the trial court actually put in its order that he was guilty of violating the city code, and that he was convicted. Those are the words of the court, and that the...
What else would you call it?
A judgment. It's just a judgment, a civil judgment. It's not associated with guilt.
What about the definition of conviction that's in the code for that particular chapter? Doesn't that definition include civil matters? And for what it's worth, you started with 409, which was about where the word conviction is used, and they specifically mention local ordinance relating to motor vehicle traffic control. That's exactly what we have here. So weren't they using the word conviction in a much broader way based on A, its use in section 409, and B, in the definition of the term conviction that's used at the beginning of that chapter?
That's what the case comes down to.
Well, thank you. I asked a good question.
Well,
How about a good answer?
There are three issues, and one deals directly with whether the city has the authority or jurisdiction under this. There's also a 5510-306, which is a similar statute. And I've addressed that in my...
That's not the same chapter, so the definition of conviction that's in the chapter on commercial driver's licenses doesn't that one govern?
Well, it's the appellant's position that this is, by referring to conviction, and we're moving into the realm of criminal process and criminal procedure. This 5550-409...
Doesn't that depend on how one defines conviction?
I know, that's the whole thing. The only definition offered in this case so far for conviction is a sister section of 5550, which is taken from the federal regulations, word for word.
Well, how about the definition in 5550-102-15 that includes a determination that a person violated or failed to comply with the law, and it also defines a conviction as the payment of a fine or court cost. So he was assessed a fine. Doesn't that do it?
It's the whole definition of conviction. This statute, the way you're reading it, was directly is intended to apply to offenses occurring in the Sessions Court where criminal matters are dealt with, where this same careless driving can be a state charge, 55-136, failure to exercise due care.
Yeah.
It's a Class C misdemeanor with a 30-day
Isn't this the version of the due care
it's a cross.
statute?
Yeah, it's a cross between that and the reckless driving.
And so wouldn't the state have a great interest in knowing a person had been found not to comply with that statute, that ordinance?
The state could have. It's conceivable that's true, Your Honor. The question is, does the statute includes city courts with purely civil jurisdiction?
But Counsel,
16.
I bring you back to my first question. This was heard eventually before the circuit court. So even if you're right about the General Sessions argument, there is a determination here by a circuit court, not just a General Sessions court. Doesn't that essentially obviate your argument with regard to the General Sessions court?
It would be circuit civil, not circuit criminal.
Well, but circuit civil here is criminal contempt matters.
The civil or criminal, but he's charged under when he moved to circuit court, he was still charged under the city code. $50 fine, no criminal punishment. That's the basis that was carried. It wasn't amended.
And the General Sessions Court had jurisdiction for that, didn't it?
For fine only, $50 fine.
That's all we're talking about.
No
That's all he got.
Yeah,
But that's good enough to trigger the word conviction in the statute, isn't it? It mentions payment of a fine under the definition of conviction. And that definition expressly applies to the statutes we're talking about.
When you use the word, when you go to civil court and you're trying a case, whatever it might be, you're not convicted. The judge doesn't convict you. He issues a judgment against you, whether it's a landlord.
You're using a sort of a common everyday layman's notion of conviction. There's a definition here in the statutes. That's what governs, isn't it?
What governs the problem, Your Honor, is that these sections you're referring to deal directly with the criminal process of law, the 5550 section, and the jurisdiction of the municipal courts, and which this in Metropolitan Code of Laws found 16-18-302 is very careful about limiting the jurisdiction of city courts. It's spelled out in there. No, you're not allowed to do anything else other than that's in 16-18-302.
Well, it's a local ordinance violation. And yes, normally that is viewed as civil. But doesn't Section 409 directly include reporting convictions for local ordinances? And you're hung up on the word conviction. And there's a definition that is broad enough to include being found in violation of a local traffic ordinance.
I mean, don't we have to follow the statute? I mean, how can we just ignore it?
Well, I mean, does a city court clerk rummage through the TCA to find 5550-409? The reason that city courts are using this to begin with is because they're
using it for revenue.
That's the whole issue, Your Honor. If we could solve that problem, we would cure the traffic situation.
Well, if people wouldn't have wrecks on the interstate, we wouldn't have traffic problems either.
Well, the wreck could have been prosecuted under a criminal statute.
It certainly could have, but it wasn't. But it didn't have to be. Okay, you got some more argument? We've wasted a lot of time on this part.
Well,
in fact, looks like your 10 minutes is up.
The trial court.
Your 10 minutes is up, so you'll have to come back and we'll continue this discussion on rebuttal.
May it please the court. Good morning, Your Honors. My name is Matthew Garth, and I represent the Appellee Metropolitan Government of Nashville and Davidson County. As we've just heard from Mr. LeDuc, the defendant in this case has not appealed the trial court's finding that he violated the careless driving ordinance. Instead, the defendant's appeal centers around the effect of that violation on his commercial driver's license and whether or not that violation is a conviction within the meaning of state law, such that it's required to be reported to the Department of Safety. The Metropolitan Government requests that this court affirm the trial court's holding that the defendant's violation of the careless driving ordinance be reported to the Tennessee Department of Safety. The trial court found that the defendant's violation of the careless driving ordinance was a conviction within the meaning of the state statute that applies to commercial driver's license holders. TCA 55-50-409, Part C, provides that within 5 days after the date of conviction, as defined in subsection A, the clerk of the court of jurisdiction shall notify the department of the conviction. Now, as we've heard, the central thrust of the defendant's argument, and really what their argument hinges on, is the definition of that term conviction. The defendant argues that conviction means that a defendant is found guilty of a jailable criminal offense or a crime. But Metro would submit that that definition is at odds with the clear language in the statute. Also, the defendant has not provided any citation to any legal authority that would support that definition of the term conviction. The term conviction is expressly defined, and it simply means that, that there's been a determination that the law has been violated. In 555409 Part A, it specifically identifies the types of convictions that must be reported, which includes the conviction of a commercial driver's license holder for a violation of local ordinance relating to motor vehicle traffic control. In this case, first I would point that both the definition of conviction and the language in 555409, neither of those turn on whether the offense is a civil or a criminal offense. There's no indication that the definition should be limited to purely criminal offenses. Moreover, they're clear that they include local ordinances and violations of local ordinances related to motor vehicle control. That's exactly what the defendant was found guilty of violating in this case. The defendant also argues that the General Sessions Court lacked jurisdiction to report this violation to the Department of Safety. The Metropolitan government would submit that this is a misunderstanding of the nature of the jurisdiction that the General Session Court has.
Counsel, do we even need to consider that issue? And isn't the final reporting here from the circuit court, not the General Sessions?
That's correct, Your Honor. That is a valid point. This case was appealed from General Sessions to circuit court. There was a de novo hearing. So at that point, really, any discussion of General Sessions Court really is no longer relevant. The circuit court was the one who heard this, you know, from scratch, essentially, starting over. They made a determination that the defendant violated the careless driving ordinance, and so the circuit court clerk really is the clerk of jurisdiction under the statute. I would also point out that under the Metropolitan Charter, the General Sessions Court clerk for civil violations is the circuit court clerk. So they're one and the same entity. But the defendant argues that the General Sessions Court lacked jurisdiction. He refers to it as the Nashville Municipal Court or the Traffic Violations Bureau. As we set forth the history in our brief, there were two separate courts that were consolidated under the Metropolitan Charter. There were municipal courts that had purely civil jurisdiction. There were General Sessions courts that had civil and criminal jurisdiction. Those have been consolidated into a General Sessions Court, which has all of the jurisdiction and authority that both of those courts formerly held.
And counsel, did you say that the criminal court function has been transferred to the circuit court out of General Sessions? Is that?
Prior to the consolidation, there were General Sessions courts that had both civil and criminal jurisdiction. There were also municipal courts which only had civil jurisdiction. When those, pursuant to state statute, I believe it's TCA 7-3-311, the Metropolitan government consolidated them into a single court that consisted of 9 divisions called the General Sessions Court, and it exercised all of the authority that had been vested in both of those courts.
But what about the clerk's functions, though? Were they all vested in one General Sessions clerk's office, or was that divided up in some fashion?
It was divided up, Your Honor. Okay. So for criminal matters, the General Sessions Court clerk is the court of the circuit court for criminal, yeah. And then there's a separate for civil.
So the circuit court clerk is the clerk for municipal violations.
That is correct, Your Honor. It's
Thank you.
The General Sessions Court clerk is the circuit court clerk under the charter.
Because violations of municipal code are civil matters.
That's right. Yes.
Metro cannot make something criminal.
Yes, Your Honor, that's correct. So based upon looking at the plain language of 409, the defendant's violation was of a local ordinance that is encompassed within the definition of conviction in that section. And so the Metropolitan government's position is that the trial court's determination should be upheld. This court should also uphold the trial court's denial of the defendant's request for injunctive relief. The defendant has argued that upon entry of a conviction and reporting the violation to the Department of Safety, that he will face immediate and irreparable harm.
Counsel, what's the extent of the adverse action taken by Metro in terms of this determination?
That's a very good question. The Metropolitan government's role in this proceeding really ends upon a determination that whether or not the law has been violated. So the Metropolitan government has only sought a $50 civil fine, which is the maximum penalty that's allowed under law.
And from Metro's, in terms of Metro enforcement, Metro's position, that is the full extent, that and actual reporting, that's where it ends.
Yes, Your Honor.
When is the report made? Is it when the court has a conviction, or is it after an appeal has happened?
The statute says that it's within 5 days of the conviction.
Okay.
That's what 409
that's right.
States.
Do we know if the report has actually occurred here?
I don't believe that it has, but I can't say for certain if it's happened or not. But to the point about the injunctive relief, I would submit that at the trial, the defendant has not shown any of the factors that a court has to weigh in order to determine whether an injunction should be granted. Furthermore, both federal and state law prohibit the masking of violations for a commercial driver's license holder. The Code of Federal Regulations provide that a state must not mask or defer imposition of judgment or allow an individual to enter a diversion program that would prevent a CDL driver's conviction for any violation of a state or local traffic control law from appearing on the driver's record.
This is not an offense for which a commercial license would be suspended mandatorily. It's one that is discretionary and depends perhaps on other violations having existed too.
Yes, Your Honor, I believe that's correct.
So you have no control over that, do you? As Metro. I say you. Metro has no control over it. You probably don't either. But I'm talking about Metro here. That's totally up to the state. So after you report, your point is that you got nothing else to do with it.
At that point, it's out of our hands. I mean, we really have no control over what the Department of Safety does with it. So the request for an injunction in this case would essentially violate the federal regulations that prohibit masking, because without reporting it to the state, it's not going to go on his record, and that's not permissible under federal law or state law for that matter. So based on those reasons, this court should uphold the trial court's denial of the injunctive relief.
You have any position on whether it would be excessive punishment to suspend his license since it's not within your bailiwick?
Yes, Your Honor. That was actually the next point I was going to turn to. So the defendant argues that by the violation being reported to the Department of Safety, that would amount to an excessive fine or punishment under the Tennessee Constitution. But as I've explained, the Metropolitan government's role in prosecuting this ordinance ends upon a judicial determination that the law has been violated. At that point, the Metropolitan government really can't be held responsible for whatever consequences result that the Department of Safety determines. So, really the defendant doesn't have standing to challenge the Metropolitan government for something that's really beyond our control. So for those reasons, I would just respectfully request that the court affirm the trial court's determination that the defendant's violation of the careless driving ordinance be reported to the Tennessee Department of Safety. Thank you.
Thank you. Mr. Leduc?
The act of forwarding a conviction to the Tennessee Department of Safety results in by operation of law, results in harm to the convicted driver's driving record. 55-409B specifically states that they must, within 5 days, submit evidence of the conviction to the driver's home state, in this case, California.
Counsel, the entity, though, that's taking adverse action beyond $50 is a state, though, not Metro, right? And
Well, the city gets involved when they're the ones forwarding the information to the Department of Safety.
they're not taking away the city's not taking away his driver's license or whatever adverse consequence flows. I have down the line here, it's a state that's taking it away, is it not?
Well, by forwarding it to Department of Safety, they're participating in the punishment.
Yeah, but it seems like your client's argument's with the state, though, in the end, saying, for whatever reason, this conviction should be ignored.
The reason that I'm here today, Your Honor, to be honest with you, is because the Tennessee Department of Safety interpreted 55-409 to include city courts. City courts aren't going to go and look for that on their own. And TCA 55-10306, which is a companion, also a similar reporting statute, at the end of that, states that the Tennessee Department of Safety can train courts. And they have a right to train the courts that deal with criminal actions. And
Counsel,
I think,
can I ask you a question about 55-409? So there's a reference in there, any violation of state law or local ordinance. I believe Judge Bennett brought up the local ordinance point earlier. Can you give us an example of a conviction something that would qualify as a conviction of under a local ordinance?
what would?
So 55-409, the conviction of any resident or non-resident holder of commercial driver's license of any violation of state law or local ordinance relating to a motor vehicle traffic control. And you're saying that conviction doesn't include this. This is an overreach in terms of conviction. Is there a local ordinance that would qualify as a conviction or
susceptible to, that would fall under this?
That would fall under that. That would meet your understanding of a conviction. Otherwise, I'm struggling to see.
No, there's nothing. As a matter of fact, Your Honor, before I forget, there's a case, City of Knoxville versus Brown, Tennessee Supreme Court 2008 case that dealt with a civil judgment regarding photo camera enforcement of red light violations. The court, whether it was citing the statute or the court approved that this is a civil offense only, no criminal punishment, and it's specifically not to be reported to the Department of Safety. That's kind of what we should be dealing with in the city courts, but we're not. And the reason this red light enforcement camera, for some reason, they couldn't prosecute it as a crime. It had to be prosecuted civilly. That's what that 284 Southwest 2nd 330, I refer to that in my brief. That's what the city courts should be. It's not their job to, unless the legislature gives them specific authority to do that, but the 16-18302 doesn't mention anything about reporting, getting involved in the criminal process. The whole premise is 55-409 is a criminal issue. And the trial court specifically found that this case was quasi-criminal. It was in his order. And he cited 6 cases. And 4 of those cases I listed in my brief. They deal with the allowing double jeopardy to apply to a civil matter. And the Supreme Court has held that double jeopardy does apply to civil cases and that right to a jury trial can apply to traffic cases. But it's whether or not it's a civil matter or quasi-criminal. If it's quasi-criminal, however the court defines quasi-criminal, it's the appellant's position that does not does not push this case over into the criminal
Your
process.
your time is up. Thank you very much.
Thank you.
Thanks to both of you. Very interesting case. Would you call the next case, please?
John Patton et al. Versus Anita